My Lords, I appear on this appeal for the appellant, Mr. Saini QC, Mr. Azzopardi QC, and Mr. Fatima appear for the first respondent. There's no attendance or representation by the second respondent. I feel as though I've drawn the short straw at the moment, my Lords, and the application I am about to make is clearly unwelcome to your Lordships, not comfortable with this advocate either. My application to your Lordships, by consent, is to adjourn the hearing of this appeal to the first open date in the new year, with no orders to costs so far as the costs thrown away by the adjournment is concerned. The agreement to ask your Lordships to adjourn was reached overnight. I realise, we all realise that this, if there is an adjournment, that this will be a massive inconvenience to the court and a serious waste of judicial time, and we accept that we're entirely in your Lordships' hands. There have been negotiations between the parties to settle the litigation between them. There are three parties, so far as this litigation is concerned. First, there are the parties represented by my clients, the Appellant, Vizcaya Partners Limited. Secondly, there is the trustee in bankruptcy, Mr. Picard. And thirdly, there are a group of companies, one of which is the second respondent, Safra. But when I refer to this litigation, I in fact mean not just this one case which is before your Lordships, but also litigation in New York, in the US Bankruptcy Court, also other litigation in Gibraltar. This is only one of at least three claims that are being brought by Mr. Picard against my clients and others in Gibraltar, and also litigation in the BVI. The parties have been negotiating a settlement for some time, and I believe the court has a letter from Brown Jacobson, the solicitors for the first respondent, dated the 8th of December 2015.
Yes, we've seen that.
Yeah. I'm instructed that there has been some progress in the negotiations to settle this case since then. I have not myself been involved in the negotiations at all, and I speak therefore entirely on the basis of instructions. I understand that my clients and the other parties now before you, and all the parties to the negotiation, therefore feel that it would be useful to the conclusion of a settlement if there is no hearing today. I cannot put it any more precisely than that. This, as I say, is an application by consent, and perhaps having said all that I can think of to say in order to achieve what I'm instructed to ask for, perhaps I can leave it to my learned friend, Mr. Saini.
Lord, I know a little more than my friend in terms of where matters have got to, and we wrote last week on the 8th of December, you had that letter. At that point in time, a deal had been done in principle, but terms were being finalised. As between my clients, that's Mr. Picard, the trustee, and Mr. Driscoll's clients, the terms have now been agreed. So the agreement hasn't been signed, it awaits approval of the bankruptcy court, but things have moved on since the 8th of December. So certainly as between myself and Mr. Driscoll, there is no further negotiation to happen. And therefore we do support Mr. Driscoll's application. We appreciate the huge inconvenience it causes to the court, but I do echo his comments, which is that the parties believe that it would be the interest of achieving a settlement for there to be no hearing today.
What, because one or other party might discover some unpalatable truths, or what?
Well, I can't speculate. I think we're in a sense, we're both in the hands of the New York lawyers. This overall deal has been negotiated amongst the parties' New York lawyers. We've merely been the recipients of communications from them. Those are our instructions.
I understand that. I mean, from the court's point of view, it isn't so much inconvenience As a day's been set aside, the court's been, other cases are waiting in the list. You've got your day in court, and here we all are. If either you've settled or you haven't. If you haven't settled, then it seems to us, I think I speak for the board, that you've got your day, you can go ahead, you can argue it. If the case then settles, fine. If it doesn't settle, then the day hasn't been wasted. But since we're all here, it seems to us that it's appropriate to have the case argued. You're not going to get a decision today, and that's the right way to proceed. Unless we're given a good reason as to why that shouldn't happen, it seems to us that that is the appropriate course to take. But
Well,
yes, please.
The only reason I can give is, as between myself and Mr. Driscoll's clients, our instructions, but the instructions are that a deal has been done.
Well, in that case, no doubt the appeal can be withdrawn.
Well, I believe that the main reason for holding off on that course is that, as we've indicated in the correspondence, there would have to be an approval of the US Bankruptcy Court.
And is it also the case that the deal that's been done is effectively conditional on further negotiations between other parties?
I believe that Mr. Driscoll will know more about that than I do, but I can only speak for my clients, and but that may well be the case, my lord.
I mean, without wishing to be too trite, a deal's either been done, in which case it's the end of the matter, or it hasn't been done, in which case it isn't. And for you to be able to come back and have the case re-argued just seems a waste of this court's time, not from our selfish point of view, but in terms of other cases coming along. And if it's got to be re-argued, it might as well be argued now. And if it hasn't got to be argued, then we haven't wasted today because we're all here. That is how it strikes us. And I think unless you can come up with a good reason as to why we shouldn't proceed in that way, we really have to put you to your election, either to discontinue the appeal or agree the appeal be allowed or whatever is the appropriate form, or we proceed, unless you can give us a better reason than you've given us so far.
Well, it's Mr. Driscoll's appeal, so I'll leave it to him to address that point.
My lord, I don't believe I can say any more than I have said, that we are not in a position to withdraw the appeal, and we do not intend to do so.
What about third parties? What about my lord's point? Is it right that this may be conditional on third parties?
The third parties, without disclosing too much, the third parties are in fact the group of companies of which Vizcaya, the appellant, is one, and a group of companies of which Safra are another. There are therefore internal negotiations on my side, rather than negotiations with Mr. Picard. But as with all these things, there are documents, and they have been drafted, and they are in some detail. They've not yet been finally approved. And that, I think, is the position.
Do you want time to consider what to do, or in light of what I've said, do you want to proceed with the appeal?
My lord, yes.
Fine.
My lord, this is an appeal from the Gibraltar Court of Appeal.
Yes.
Although the appeal is concerned with the question of Gibraltar law is the same for the purpose of this appeal as English common law. And therefore, if I may, I will address you on the assumption that this is in fact an issue for an English court applying English law.
Yes. Now, we've read your statement of case, which is very clear. Is there anything you want to add to it?
My lord,
because I don't mean it rudely. Indeed, if anything, it's a compliment. We see what you say and understand what you say. If you're simply going to go through it, there isn't much point, because we've taken it all on board.
my lord, yes. Then, my lord, may I leave it that if appropriate.
Can I ask one question? Namely, you say it's all subject to English law. Mr. Saini says in response, and it's not right, it's an American or New York contract, and therefore the construction of the contract is a matter of New York law, and the words may mean different things in New York, and I've looked at the piece of evidence he relies on. Do you accept that he's correct on that?
My Lord, no.
Well, why do you say he's wrong?
You say correct on that, do you mean correct on what New York law is?
Yes, no, sorry. Correct that the construction of the contract is to be conducted according to New York law principles of contractual construction.
Yes.
So you accept that's correct? But you say, you've said somewhere that no evidence has been put forward to suggest that New York principles of construction differ from English principles of construction.
My Lord, yes, that is, your Lordship has it.
So I'm right up to that. That's your case.
My Lord, that is my case, yes.
Well, on that basis, we're simply arguing about whether, I've forgotten his name, the American experts, the second one,
Zeballos.
whether his evidence amounts to evidence about Zeballos, principles of construction, or whether he isn't addressing a completely different point, namely whether under the US long arm or short arm jurisdiction based on conducting business, in other words, Rule 3 of whatever the rule is, or Sub-Rule 3 and whatever the rule is in Dicey, there isn't in New York eyes a de facto submission.
Yes.
And so am I right that that's the
Your Lordship is absolutely right, yes.
Is he saying anything more than really the equivalent in English law, that contract made in England or contract governed by English law is subject to service out of the jurisdiction? And if you substitute service out of the jurisdiction for the equivalent term in New York law, which is specific jurisdiction, he's not saying there's been a submission, he's simply saying that where there's a contract made in New York, it is subject to the specific jurisdiction of the New York courts under Section 302 of the CPLR.
My Lord, yes. I was going to draw the court's, the committee's attention to your Lordship's own observations in Rubin on the distinction which exists between the rules which would guide an English court in deciding whether or not to admit a claim which is being made before it, and the approach of the English court to the recognition of foreign judgments. And I was also going to swap my authority of King and Brandywine on the question of the court's approach to interpretation to the judgment of my Lord Clerk in Al-Hamrani and Al-Hamrani, but small points.
Anything else? No. Thank you for the moment, anyway, Mr. Bristol. Mr. Saini.
Lord, I'm going to divide my submissions into 4 chapters, and I'm not going to repeat what's in my case, but I'm going to seek to answer some of the points made on the authorities in particular. First, I want to do an introduction and to explain what we say the issue is and what our answer is in summary to the issue. Yep. Secondly, I want to look at the judgment, the default judgment of the US court and the process that led to that judgment, because it's not simply a default judgment that appeared without any reasoning. And it's quite important to look at the reasoning of Judge Liflin in the bankruptcy court to see why he entered default judgment. Thirdly, I want to go to the issue of construction. And finally, I want to deal with the cases relied upon in summary. If I can start with my introduction and what we say the issue is, and what our answer is in summary. We said that the issue before the court is primarily an issue of contractual construction, applying well-established principles of conflicts. Contrary to what Mr. Driscoll says, we certainly seek no extension of the law. We're trying to establish in our case, or apply well-established principles. So in summary, the issue before the court is whether the particular wording used in Clause 10, which the court will be familiar with, Clause 10 of the Customer Agreement, amounts to a contractual agreement or a submission to jurisdiction within Dicey's fourth case.
Yes.
And the New York Bankruptcy Court is a court that issued the judgment, and as the court knows, that's part of the Southern District in New York.
Yes.
Now, there are 4 important points which we say should be uncontroversial, four important propositions of law, which I want to outline in opening. First, that the Gibraltar Court must apply Gibraltar law conflicts principles in deciding whether or not there has been a submission by agreement.
Yes.
So we're applying Gibraltar and English law.
Thank you.
Secondly, when the submission is said to arise by way of an agreement or a contract, Gibraltar law conflicts principles oblige the Gibraltar Court to construe that contract under the chosen law.
Yes.
Now, that's simply a result of the faithful application of Gibraltar law conflicts principles.
Yes.
Thirdly, if the construction of the agreement under its chosen law reveals that the language used by the parties operates as a contractual submission to the courts of a particular place, then there has been a submission.
Yeah.
And then,
Wait a minute, we're not talking about submission, are we? That's a different sub-rule. We're talking about whether there has been a contractual agreement to submit.
my lord's absolutely right.
Submission is something which you judge, presumably according to Gibraltar principles of private international law, and as a matter of looking at the material and asking whether, according to those principles, this can amount to a submission.
Indeed, my lord. I was using it.
If you're there and you see an office there, you ask, is that under Gibraltar or English principles of private international law sufficient to amount to a submission to the jurisdiction for either all cases or else for cases of contracts made through that office or whatever? It's a different question from an agreement, isn't it?
My lord's absolutely right. I should have used the more accurate language.
Agreement to submit.
Contractual agreement to submit rather than submission. Because my lord's absolutely
You've got
right.
to find a
Submission is a
contract.
wider, potentially wider concept.
Yes.
Okay.
Also, when you're talking about applying the foreign rules of interpretation, it is only the foreign rules of interpretation that the court applies, not it's not the foreign application of those rules.
Well, I need to be absolutely clear about that. What's the crucial wording in this case, as the court will already have seen, is the wording at the very beginning of clause 10, which is contract deemed to be made in New York. As I'll come to submit, that's a term of art. So anyone making a contract in New York will appreciate that that's a term of art in New York, which has certain consequences. And in order to know what that term of art means, one has to look at New York law. Because it doesn't mean anything. In England, those words don't mean anything. But to a New York lawyer, it
Well,
means
that's not a question of meaning, that's a question of legal consequences.
Indeed, well, it has a particular legal consequence. The fourth point I was going to make, just by way of opening, is that when one looks at terms of a contract subject to a foreign law,
Yes.
one has to be consistent in applying the foreign chosen law to all of the terms. So one can't, as Mr. Driscoll does at some parts of his case, one can't look at certain clauses and say, actually, I'm going to look at that as a matter of English law. Because when it comes to conflicts issues and questions of contractual submission, we've got to apply English law. You've got to apply New York law to the entirety of that contract. So the clauses which concern issues of potential contractual agreement, you've got to construe those under New York law, not under English law.
Yeah, you'll come to it at some point, but the difficulty I find is that I can't see any statement that New York principles of construction are in any way different. Indeed, I can't see any statement as to what New York principles of construction are.
Well,
But you'll come to that.
Lord, it comes back to this question, what I call a term of art, which is a question of there's some wording that begins at the start of clause 10.
Yeah.
And when I was to ask, what do the parties understand that clause to be achieved, those words to be achieving? And as a matter of English law, without any education in New York law, there's not much that can be concluded from those words. And Mr. Driscoll, in his case, postulates some reasons why parties may have included those. And I think the example he gives is tax. It may have been that they put that wording in, the contract is deemed to be made in New York, perhaps for tax purposes.
Well, isn't it fairly obvious that what it is likely to mean is that it's the equivalent of having, so to speak, an office there. You are there. But that's a different point from whether you've agreed to submit.
The question is, what's the consequence of that? And we say it's very easy to say the consequence of that was that the parties were putting that wording in there because by using that wording, which is a term of art within New York, they were agreeing that the New York courts were going to have jurisdiction, because there's no other meaning.
Well, a term of art normally means that you've got a word which has some special meaning in New York that is different from its meaning in England. Now, what do you say was the word or words that constituted a term of art? Or are you really only saying the whole of this clause is understood to be a submission in New York?
Well, the wording at the beginning of the clause has a certain legal consequence to New York lawyers.
But which words do you say means
Contract deemed to be made in New York.
I believe, I may be
Yes.
wrong on this, the reason why those words are found in New York contracts, and I think they used to be found in English contracts, was that under the influence of Beale, there was no concept of the proper law of a contract. Contracts under old US conflicts law were governed by the law of the place where they were made. And therefore, the way of choosing New York law was to say it was deemed to be made in New York. That was the historical reason. And now, whether it's grown from that to amount to an implied submission, and I haven't seen that in any of the evidence, may be right. So is it in the evidence?
Well, we say...
Where is the relevant bit of the New York law evidence we should be looking at?
I'm going to come to it's going to be Mr. Zabayas' evidence, and I'm also going to show you the judgment of the court which led to the default judgment,
Yes.
and how Judge Liflin came to find that there was that he had jurisdiction
Yeah, I mean,
over.
this is the absolute core, it seems,
Absolutely, yeah.
of the issue between
Absolutely.
you, ultimately.
And so what one gets to is that one sees the words in various other cases concerned with contractual submission. Essentially, what was the bargain made? Is there some indication in the contract? And it's most clearly in Lord Justice Scott's judgment in Adams and Cape, which is there some indication that they were consenting to the jurisdiction of the foreign court? That's really the underlying principle in the fourth case. And we say that wording that appears at the beginning of Clause 10,
Right.
as identified by Lord Justice Potter in paragraph 53 of the judgment. And if I can take you straight there, paragraph 53 of the judgment of the Gibraltar Court of Appeal, which is the nub, in a sense.
Yes.
So it's 50, starts at 52
Right.
and goes on to 53.
Okay.
Sorry, this is...
It's in the
Page 28.
page 28 of the judgment, my lord. Paragraph 52, beginning, however.
Yep.
And here, the judge is dealing with the contrast between this clause, the clause 10, and the clauses in the earlier case, particularly in the case of Dunby and Gilman. And there, Lord Justice Potter observes as follows. However, that is not the position in this case. That's comparing our clause to the clause in Dunby and Gilman. As Ms. Fatima rightly submits, Clause 10 differs materially in its terms from the choice of law clause in Dunby and Gilman, in particular by the express provision contained in the opening words, this agreement shall be deemed to be made in the state of New York. And it is upon those words, coupled with a balance of the clause requiring that the agreement be construed under New York law, that she relies upon as amounting to an implied agreement to the jurisdiction of the New York court. And then he refers to this evidence.
Well, that's nothing to do with terms of art.
It's a consequence. It's a consequence of those words.
It's a matter of implication.
Indeed.
I
Well,
don't
though-
quite see how implication has anything to do with the special meaning of words in New York.
What?
By definition, the words don't get you there.
Well, perhaps I can put it more directly, my lord, which is that in New York, those words have a particular consequence.
Yes, but that's a different concept to the term of art point.
It may be, my lord, that we're disagreeing about terminology. My submission is simply this. As Lord Justice Potter, we say, correctly identified there, those words lead to a particular consequence. We say, what's the bargain that's been made between the parties? The bargain that's been made between the parties is that as a result of using these words, we are agreeing.
Well, are you agreeing? You are agreeing that the contract is made in New York. Now, New York law may attach a significance to that, simply because it is the same as if there was an office there or as if someone had gone there to do business and had signed the contract in a hotel. That, under the specific jurisdictional provisions, could amount to a sufficient jurisdiction, as Lord Collins has said and I've said before, a sufficient jurisdictional basis to enable suit, a long-arm jurisdiction based on presence in the jurisdiction. But does it go any further than that? Well, why should it go any further than that? Because that would be sufficient for New York law purposes, presence in the jurisdiction, doing business there. One knows that the Americans have had quite wide jurisdiction in the past, which has been cut back, in fact, by the Supreme Court. This seems to be explained, again, you can take us to the material, as, well, even in the judgment, just looking at the your own statement of case, 30.7, as going to the application of the long-arm statute.
Well, Lord, there are two different positions here. One is, let's imagine we had that agreement without that wording at the start of clause 10. So simple, yes, plain choice of law.
Yes.
And the argument, we would not be having this argument about a contractual agreement at all. But this is not that case. This wording, we say, has been agreed between the parties as a matter of a bargain. The bargain being, by agreeing these words, which have a specific consequence in New York, I am agreeing, both parties are agreeing, that the New York courts will have jurisdiction.
I think we ought to look at the evidence which supports that proposition.
I mean, there are two stages in that argument. You agree a specific wording. It doesn't follow that you're agreeing what the New York courts would derive from that wording, namely that they have long-arm jurisdiction. That is a matter of statute, isn't it?
But it's simply parties agreeing in a particular legal context, parties are agreeing certain wording, and one would assume that those parties know what the consequences of that wording
What
are.
do you say the consequences were? There are two possible consequences. One is that the New York courts have jurisdiction under their own law, and the other is that there is what English law would regard as a submission. Yeah. Those are two different things.
We say, my lord, it's a submission because the parties have gone to the trouble of agreeing some specific wording. They could have remained silent, and then there could have been an argument.
Does the evidence support that?
Well, I'm going to come back.
Let's look at the evidence.
Okay. If I could take it in stage, so I'm going to the second part of my submission now, which is the judgment of the court and the process which led to it, and then the evidence in relation to what the position is in New York. Because
yes, we can see what the court. This is the judgment of the Court of Appeal of Gibraltar.
no, the judgment of the U.S. court,
Quite.
which led to the default judgment.
Okay. You want to go to that before we go to the evidence?
Indeed. Well, I'll do it all as part of this second section.
Okay.
Which is so. And in order to put this in context, if you can go to the record, please.
Yep.
In tab 8, which
Yes.
is the original complaint.
Yes. Yep.
And if you could please go to page 102, paragraph 60, which is
Yes.
what was in the original complaint in the US in 2009.
Yes.
And if you look at the first sentence of paragraph 60, please.
Yes.
This court properly has jurisdiction over the defendants, and then it carries on, by their terms, the Vizcaya account agreements were deemed to be entered into the state of New York and were to be performed in New York. I can just stop there for the moment.
Yep.
So there's an express reference there, not just to the general fact that there was to be some performance of the contracts in New York, but specifically the fact that there was a contractual specification. The parties had agreed something.
Yes.
That's the first stage. What then happens is that Vizcaya,
Yep.
this is not a case where Vizcaya don't know the procedure.
It's a transactional basis. If you look over the page on paragraph 61, they relate, they say that it's out of these transactions that the instant action arises. They've therefore submitted themselves to the jurisdiction.
In addition to the fact, so these points all come together, in addition to the fact that there was a contractual specification, see the second sentence of paragraph 60, that's expressly relied upon. The consequence of that contractual specification of deeming to be made in New York, plus the further facts that my lord has identified, lead the trustee to say that there is New York jurisdiction. So it's not a case where the trustee was simply relying upon the fact that there happened to be some business done in New York.
Okay.
The contractual specification is crucial, that's what distinguishes
But
this case.
If you look to the last sentence, defendants therefore have submitted themselves to jurisdiction of the courts of New York. paragraph 60 deals with a whole host of
Indeed.
different points leading to that conclusion.
Including the very first point, including the very first point, which is there is a contractual agreement here.
Yes, but the trouble is we don't know which of those grounds were, well, on the face of it, we have a number of grounds.
Indeed.
Yep. Okay.
And then if one goes on to tab 9, so that just to explain what was going on, this is not one of those cases where Vizcaya has been served with proceedings that it doesn't know about. In fact, what happens is that Vizcaya hires lawyers in New York, and they decide, after having sought various extensions of time, see tab 9, page 10, paragraphs 38 and following, having sought various extensions of time, having spent quite a bit of money on New York lawyers, Vizcaya decides they're not going to bother responding.
Then page 128.
Page 128,
Okay, so
paragraphs
that's-
38 and
The
following.
motion for default judgment.
That's right.
They decide not to proceed, right?
Yes.
Okay.
And then one goes back to the question of personal jurisdiction in the motion for default, paragraph 53, page 131.
Thank you. Yep.
But this is all concerned with jurisdiction under New York procedural law.
Indeed, indeed. But paragraph 53 is a description of the general law.
Yes.
But if one goes, please, to paragraph 55,
Yep.
page 133.
Yes.
In fact, if I can pick it up at the top of page 133, if you'd please go to the second line at the top of page 133. In addition, which is reflecting what was, in addition, the amended complaint alleges that Vizcaya account agreements were deemed to be entered in the state of New York and to be performed in New York. Then at paragraph 55,
But that's an additional argument.
indeed,
Yep.
and paragraph 55, in an earlier case decided by this court, the court found that personal jurisdiction was established when a complaint included allegations stemming from the avoidance of fraudulent transfers arising out of the defendant's agreements account transactions. Defendants opened their account by executing a customer agreement deemed to be made in New York and subject to New York law.
But if you go back to 54, and perhaps I've misunderstood this, the basis of jurisdiction under the New York long arm statute, which is 302A1,
Correct.
was transaction of business.
Indeed, but in this case, what we not only have transaction of business, but we have the parties specifically agreeing in the wording of clause 10, in the first few lines, the first few sentences.
Yes, but there's no separate head under CPLR 302 for submission by contract, is there?
Well, there is actually, I think,
Or relied on anyway.
Is it in 302A1?
I think it's set out in Lord Justice Potter's judgment, actually, in the paragraph we were looking at a moment ago, paragraph 53.
That's very helpful, thank you.
Yes, one goes back to paragraph
Yes,
53.
well, that's transaction of business.
Yeah, so it's transacts business anywhere.
Yes, so that's not in point.
I mean, New York law, no doubt, like our law, has a specific head for specific agreements to submit to the jurisdiction.
Yes.
So, I mean, you don't, where do we find that alleged? What we have is reliance on the transactional basis which exists under the long arm statute. What one would expect is if this is understood as an agreement to submit simpliciter, a specific head relating to agreements to submit would have been relied on.
Well, the point is, my lord, we come back to the position which I started with, which is that the parties have used some wording. And the wording, we say, is the parties agreeing.
It doesn't answer my point.
Indeed. Well, my lord, it doesn't say we are agreeing to New York jurisdiction as it could have done, but it's using some other wording. Then the question is, what's the consequence of that wording?
Yes, I think you accept there's no submission head of the CPLR. What you're saying is that in a process which I'm not yet understanding, that although there's no submission head under the New York CPLR, the consequence of the wording deemed to be made in New York is, by English standards, a submission to the jurisdiction of the courts of New York to enable them to exercise jurisdiction on the transaction of business head.
Indeed, my lord, because it has no other meaning, that wording. It makes no sense, and certainly Mr. Driscoll has put forward no evidence as to why else that would be there. And we know we're still going through the history of the proceedings in New York.
But my question to you is, why on earth would New York law regard this as a submission when it doesn't need to? Because all it's saying is that if a contract is made in New York and has other various minimum contacts with New York, the New York courts may exercise jurisdiction on the basis of transaction and business?
Well, because it may otherwise have been open to and this is a customary agreement, which I remind the court is a standard form customary agreement applied across the board. It may have been open to a defendant to say, in fact, in my particular case, there isn't minimum contact under the general law.
Minimum contact is another
Yes.
issue. That's a question of constitutional law. The
Yes.
question is whether it comes within any of the heads of jurisdiction of the New York CPLR, of which the most important one, for the purposes of specific jurisdiction, is the transaction of business.
Well, because it may have been open to someone to argue that there is no basis for jurisdiction in the New York courts because I haven't done any business in New York.
Yes,
But this is getting rid of that argument. It's a contractual agreement. The parties are disposing that argument because they're saying the very contract is deemed to be made in New York. And Lord, I was just on going back to page 133 in Divider 9.
Yes.
What they're doing is agreeing something which New York law treats as conferring jurisdiction under its own law.
Indeed.
But does that advance the question that we've got here, which is what are the characteristics that an agreement must have in order to amount to a submission, a contractual submission, in the eyes of English law?
Well, my Lord, it does answer that question because the parties, by their bargain, and this is a purely contractual matter, are agreeing a certain form of word with a certain consequence. They're going into this with their eyes open.
This is the wrong consequence from your point of view. The consequence is that New York law has jurisdiction under its own principles. The consequence is not that there is a submission under English law.
Well, Lord, we'd say that because it's in a contract, this is not the New York court taking jurisdiction by simply, for example, the test of is there business being done generally in New York here. This is a case where there is some wording. And going back to Mr. Justice Scott in Adams and Cape, is there some indication of consent to the exercise by the New York courts of jurisdiction, that being the broad test? We say that's the consequence of this wording, because otherwise it has no consequence.
But again, going back to some of my Lord's questions, where's the evidence even of that?
Well, perhaps I could just I'm slightly going out of my plan here, but I'm going to come back to that. If I can just finish off on going through what's happening in New York.
Yes.
And you see, we were at page 133.
Yes, we've looked at that, yeah.
And then there's a reference at paragraph 55 to decided case law concerning these very terms. Paragraph 55, in an earlier case decided by this court, the court found, that's the bankruptcy court,
Yes.
That personal jurisdiction was established when a complaint included allegations stemming from the avoidance of fraudulent transactions arising out of the defendant's Bleemer's account transactions. Defendants opened their Bleemer's account by executing a customer agreement deemed to be made in New York and subject to New York law. So there's a reference to a case.
Well, read on, directed transfers.
Yes.
Yeah.
And then
So
we have some.
it's an omnibus sort of.
Indeed.
Reaching this conclusion, the court found foreign defendant's conduct established sufficient minimum contact. So
Yes.
it's transactions or contacts.
But I emphasise again, in part at least, stemming from the fact that they have contractually agreed some wording.
Would it, if they made the contract in New York, right, at a hotel, that would be a minimum contact, and this recital would have taken place in exactly the same way, except it would have said the contract was in fact made there. Now they didn't make it there, so they put a clause in saying it is made in New York.
Indeed.
Why does that alter?
We say it has a consequence because the parties there, unlike simply exposing themselves to general New York jurisdiction, they are agreeing some specific wording, and that wording can only mean, in this context, that they're agreeing that.
Surely what they're agreeing is that this contract is to be viewed as if we were in a hotel in New York.
Well, it's going further than, yes, but by way of contractual agreement. And there's a distinction. Imagine we had the facts in exactly the same way, but we didn't have that wording there. And my client was seeking to argue that as a matter of general New York law, not by reason of any particular contractual wording, as a matter of general New York law, there's jurisdiction. I'd accept that in this court, the court would say, well, that's not good enough for us. We want to see something in the contract,
The logic of your argument would be that if there had been no such clause, but it had actually been made in New York, the parties would both have been, by turning up to sign it in New York, would both have been doing an act which submitted them to the jurisdiction of New York. That would be the consequence. So I don't see why your argument would be any different in the two cases.
I think the difference is, my lord, that we have a contractual agreement. We have some
Why
wording.
is that a difference?
Well, because
Why do you concede that if the contract was in fact made in New York, your position, you wouldn't be able to argue this point?
I'm simply trying to answer the point that it's been said.
Do you concede that?
Well, perhaps I can just come back. I'm simply trying to answer the point that is there a difference, as I understand the point the court's putting to me, is there a difference to the result merely because that wording has been put in? So imagine the contract had been made in New York, but that wording hadn't been put in there.
Yes.
Now, that would be a general submission case, not a contractual submission case. Here we're dealing with a contractual submission case.
It's rather bizarre that in a sense, the jurisdictional basis you say is clearer if you're not there, but you put in at the bottom, deemed to be signed in New York, than if you are there.
Well, what this does is it's a belt and braces, in a sense, which is that there is no doubt at all that the parties sat down in a hypothetical negotiation and agreed this particular wording. And does it really have no consequence from a jurisdictional perspective? We say
It has an enormous consequence because under New York law, it is seen as a transaction which is made in New York, as if they were physically there. And New York law can attach what consequences it likes for its own service out provisions. But the consequence of your argument is that there's not only a basis of jurisdiction which may be invoked, you're saying that the parties have both contracted not to sue anywhere else.
Well, I don't need to go as far as that.
You have to. If it's an agreement to submit to the New York courts, it must be, surely, an exclusive agreement.
No, my lord, that doesn't follow with respect. As long as there is a basis for jurisdiction, we don't have to show exclusive jurisdiction.
Well, you certainly don't have to show it, but I'm just asking whether the consequence of an agreement to submit disputes to New York isn't that is where you've agreed to submit disputes. It would be a breach of contract on your argument to submit them elsewhere.
Well, my lord, it's a legitimate jurisdiction. I wouldn't go as far as to say that if someone litigated somewhere else, it would be a breach. It's simply a jurisdiction that the parties have agreed. I don't go as far as to say it's an exclusive agreement, and I don't believe that we need to show that it's exclusive. We just need to show that the parties have agreed something. But we come back to the point, my lord. I'm sorry, I'm saying this for the nth time, which is the words have to have some consequence.
No, we have that point. Now,
If I can just...
taken us to page 133, where were we going?
We're going to tab 10 next, which is the Judge Difflin's ruling
Yep, thank you.
at page 144.
Yep.
And having considered the motion, he rules at page 144. And if we can just take the wording just above that, it is hereby ordered that.
Yes.
There the judge has satisfied himself that the applicant has made a prima facie showing of personal jurisdiction.
Well, that's as obvious as anything could be, because the case has clearly some relevant New York connections.
Yes.
And sufficient not only to bring it within the heads of New York CPLR, but also to satisfy the minimum contacts constitutional provisions.
But I made this point earlier, one of the points relied upon in the application, not only relied upon in the application, but also relied upon by the bankruptcy court in the case law, which is cited in the application for default judgment. The bankruptcy court has already decided that making a customer agreement, which is deemed to be made in New York, is a basis for jurisdiction. Now, what
They also
then...
decided that the fact that it was governed by New York law was equally a basis for jurisdiction,
Well,
but you're not relying on.
No, but I'm relying on the customer agreement point, the wording of the customer agreement point, rather than the New York law point here. But then, what then happens, just staying on the evidence then, is if one goes to divider 16, please, in this bundle, which is the evidence before the Gibraltar...
Is this the expert evidence?
That's right, Gibraltar Court.
Where do we look in that?
It's page 247, paragraph 18.
Yep.
You're not concerned with his first three witness statements?
No, Lord.
Right.
And between paragraphs 18 and following,
Yes.
one sees a description there of the basis for New York jurisdiction.
Yes.
You're not relying on paragraph 18, are you?
Page will be on that.
Well, we do rely upon the fact the language of the customer agreement.
Yes.
It's
And then over the page from 21 to 25, there's a description of transaction of business within the state. And this is the evidence that was relied upon by Lord Justice Potter
Yes.
in the Court of Appeal of Gibraltar to say that, certainly for the purpose of summary judgment, because this evidence hadn't been tested at that point in time, that there was a basis for saying that the parties had agreed to New York jurisdiction.
this is on the basis of governed by New York law, not on the
Well,
basis of...
it's also transacting business as well, my lord, not just
Transacting
government.
business is the whole,
Indeed.
transaction.
Indeed, but part of the transacting business, as we've seen from the documents a moment ago, is making a contract in New York. That comes within transacting business, because that's the purpose of it.
That's paragraph 24.
Indeed.
A specific jurisdiction is established over a non-subsidiary who transacts any business within the state, commits a fraud.
Indeed, indeed. So one,
So it's again,
so that's the evidence. There was other evidence which I don't believe is in dispute, but I should just for the court's notice, I should draw it to your attention, which is in tab 15. There's expert evidence from a Professor Kenneth Klee, who is, I believe, a bankruptcy expert, and he was simply making the point that even though there was an insolvency under US bankruptcy law, and under the particular statute covering the trustee, my client,
Yes.
my client essentially stands in the shoes of Mr. Madoff's company.
Which paragraph?
This is
Yeah, which paragraph?
divider 15, my
Yeah, yeah,
lord,
which paragraph?
and it's paragraphs 14
Thank you.
and then 24.
Thank you very much.
24 in particular, page 208.
Yes.
So, which is essentially saying, in fact, this would probably be the same position under English insolvency law. Essentially, the trustee, just as a liquidator here might
Stands in
be,
the shoes.
will stand in the shoes
Yep, understand.
of the debtor, essentially. So there's the customer agreements don't come to an end as a result of that. If I can then turn to the third issue, my lords, which is the crucial issue, which is what I started, which was construction, and it may be useful here to look at the customer agreement itself.
Yep.
The relevant clause is quoted in various places, but I've taken it from divider 5 in the record,
Thank you. See if it's a sensible place
and
to
it's
take it.
clause 10 under
Page
the heading
83, yep,
choice of laws.
Yes?
Now, we say that by using that wording, it's page 83, divider 5,
Yeah.
clause 10.
It's the first
Yes,
10 words of
so
it,
the
yeah.
agreement shall be deemed to have been made in the state of New York.
Yes,
There has to be some meaning given to that wording.
yes,
And we say on the evidence before the Gibraltar Court of Appeal and before this court, the position is by using that wording, the parties were investing
yes.
the New York court with a jurisdiction, and that no argument has been put forward, certainly no evidence, as to why else that wording was used.
Did the application for default judgment disclose the arbitration agreement?
I believe that it's part of the same agreement.
No, but did it specifically?
I
Did the
don't
motion?
believe that the arbitration point was referred to in the notice of motion, Lord, if that's a question. No, I don't believe it was.
The logic of your submission is that any conscious act or any agreement which confers jurisdiction procedurally on the New York courts under their own law amounts to a submission as a matter of English law. That does follow.
It's slightly more modified, Lord, which is any contractual act.
Yes.
Right.
Any
We
contractual
might
act.
Go back over the difference between contractual acts
Indeed.
and non-contractual acts of submission, but that is the implication, isn't it? And any provision of a contract which engages the New York's jurisdiction, including its long-arm jurisdiction, is good enough.
Well, it must be a provision which is tailored to engage the jurisdiction of the New York court.
Which is tailored. Does that mean any more than that's its meaning as a matter of construction?
Well, I say that because in this case, this is not a difficult case because we have wording which only has one consequence. There is no rival argument put forward as to why the parties use that wording. And just stepping back again, what's the bargain? What is this? What this court, as the Gibraltar Court of Appeal said, needs to give effect to the bargain between the parties. The bargain that's being struck.
The bargain seems to be they won't litigate, but they'll arbitrate.
Well, I'm going to come back to that point. But what they're clearly agreeing is that the New York courts, as a consequence of this wording, will have jurisdiction. So, by contrast to the other cases where you simply have a choice of law, which is in a sense neutral.
Well, there's nothing about jurisdiction in this contract at all, is there, except the jurisdiction given to the arbitrators under clause 12.
You say that begs the question as to what the opening words of clause 10 mean.
Indeed. So,
Second point, Mike.
what this amounts to is that the New York courts have jurisdiction. There are certain disputes that will be arbitrated within the clause, that clause, which is very wide.
I understand.
Which is clause 13. But just as the position is in England, if one goes down the route of invoking the jurisdiction of the ordinary courts, obviously someone may apply for a stay, but the ordinary courts aren't deprived of jurisdiction, as would be the case in England, if someone starts ordinary proceedings rather than going by way of arbitration. So we don't, in our submission, the arbitration clause doesn't help, learned friend.
I understand.
It simply suggests that arbitration is going to be used for certain disputes, subject generally to New York federal law, as that, as the reference to the Federal Arbitration Act in clause 13 makes clear. But I do emphasise this crucial point, which we say was at the core of Lord Justice Potter's judgment, which is that this is not a case where the parties have remained silent, and we're trying to leap from simply a New York choice of law to a New York submission to New York jurisdiction, and it's all as a consequence of that wording in the beginning. Now, if Mr. Driscoll had put forward some evidence of New York law that, in fact...
You say he hasn't put any evidence, you've at least got some evidence.
Indeed.
It's at least arguable, and that's what we need.
Absolutely. And it may be, but it hasn't appeared yet, despite the fact that this case has been pored over by New York lawyers for at least 4 years, no one has come over with any convincing explanation as to why the wording, this agreement shall be deemed to be made in New York, why was that there, other than the parties signalling and agreeing that we are hereby agreeing in advance that one of the bases upon which a New York court may exercise jurisdiction is established here. And no one can argue about it, and there may well have been an argument about it if, for example, that wording hadn't appeared, and there'd been an argument, for example, about minimum contacts, was business transacted in New York, one can imagine.
But if that was their purpose, then why didn't they simply say the New York courts shall have jurisdiction?
Because they're using here a shorthand which every New York lawyer understands is planting jurisdiction firmly in the hands of the New York court.
I'm still puzzled. Where's your evidence to that effect?
Well, Lord, because it comes from what Mr. Zabias has said, which is this is transacting business in New York, making a contract in New York.
Well, that doesn't carry you far enough.
Well, Lord, that's what Mr. Zabias says. You've also seen the reference to the case law. That's been put forward in the notice of motion, where the US Bankruptcy Court has decided that a contract which is deemed to be made in New York is a contract which is subject to its jurisdiction.
All it says, apparently, is that that's one of the elements in the whole appreciation of whether there's been transaction of business.
Indeed. Well, my Lord, the position is you have evidence before you, hasn't been contradicted, as to what the New York court regards as establishing jurisdiction, and one of those points being, not the only point, I accept that, but one of the points being a contract which is made in New York, and that hasn't been contradicted.
But that can't be contradicted because that's quite obvious.
Well,
but the question is still, is there any evidence that in some way those words are deemed under New York law to be equivalent to some form of submission?
Well, my Lord, the evidence is that making a contract in New York is doing business in New York, and here the parties are agreeing that they have made this contract in New York.
Just assume this was a case of enforcement of an English judgment in New York, and the contract said this contract is deemed to be made in England and deemed to be governed by English law. no English lawyer would have any problem in saying those two factors give the English court jurisdiction as they do under Old Order 11 and the practice direction. What is the difference?
Well, in that situation, the parties would be agreeing an appropriate jurisdiction. In New York, they'd be agreeing an appropriate jurisdiction for disputes is New York. They may not be going that far in England, because the point that my lord puts forward to me may be a basis for giving leave to serve out of the jurisdiction under the Practice Direction 6. But in New York, the position goes further, which is the parties are expressly doing an act by contractual agreement, which is giving the New York court jurisdiction.
Am I right in thinking that the highest point on this current question at which your evidence attains is at page 248 in Mr. Zabalos's witness statement between paragraphs 22 and 24?
Well, certainly the transaction of business within the state.
But does it anywhere state that merely signing the document is transacting business within the state?
Well, in a sense, saying that we're especially agreeing, we're warranting to one another that we are making this contract in New York, we submit that is a transactional business within the state. And in fact, the references I gave the court earlier, both to the complaint and to the application for default judgment, makes it clear.
Yes, if that were the only connection, then a defendant contesting the jurisdiction would be entitled to say, even though it was made in New York, there are no other connections with New York, and therefore there are insufficient contacts
Indeed.
with New York law to satisfy the constitutional requirement of minimum contacts.
Mr. Azapard, you asked me to draw your attention to paragraph 20 as well, bottom of page 247.
Well, again, that's based on governing law, which you're not relying on.
But just related to this issue of the wording, the ultimate point that Lord Justice Potter was making was that there is a credible case put forward at this stage, which hasn't been challenged, that the contractual wording leads to a submission. It's still the case.
Because it amounts to a transaction of business within the state.
Indeed. But this...
Paragraph 24.1, is that the argument?
I'm sorry, my lord.
Paragraph 21.4.1 in the witness's statement.
Yeah.
I mean, he has three classes of specific jurisdiction, and the only one that's relevant, potentially relevant, is one.
That's right.
And the whole case turns on that.
Indeed.
Whether or not the first few words of clause 10
and what distinguishes
amounts to the transaction of a business within the state.
Okay. And what distinguishes this case, my lord, and what I think the questions that have been put to me ultimately are suggesting, well, what's the difference? The fact that they put this wording in, imagine the wording wasn't there, and in any event, there'd been some business done in New York. Does that make all the difference? We say...
You seem to be saying earlier that if the documents at the end said made in New York and the contract was signed, that wouldn't be sufficient.
Well, what I'm saying...
I think you have to say it would be sufficient.
Well, what I'm saying is that we've got some wording, and we've got to give some effect to the wording. And I come back...
What you give is the same effect as if it said what my lord said. It's deemed to be made there, so they didn't actually go to New York, but it's to be treated as if it said at the bottom, signed in the Hilton in New York.
But the next step, my lord, is the fact that they bothered to do that must have a consequence.
Well, it certainly has a consequence, namely that this may well be regarded by New York courts as a contract made in New York. But parties, and that may give them jurisdiction under their long-arm statute.
The question is, what does the English...
It doesn't follow that all the consequences which New York law attaches to a contract are to be deemed to be things which the parties have agreed.
Well, Lord, with respect, I wouldn't agree that. In a contractual case, the parties... This is a contract between commercial parties that have agreed certain wording which must have a consequence. And we say that the English court's role, applying established principles, is to give the contract those consequences. What one can't do is to ignore the consequences by applying some English law conflicts principle. And essentially what Mr. Driscoll is saying comes to this, which is that Clause 10, when you look at it purely through English law eyes, doesn't look like a contractual agreement to submit to the jurisdiction of the New York courts. And we say, well, applying New York law, that wording has a specific consequence. And it would be very odd indeed if this court said, well, I'm not going to give any consequence to what the parties have agreed. And that's why there is a real distinction, although we don't have to ultimately deal with it in this case, a distinction between using wording and simply undertaking certain acts which might give the New York court jurisdiction. And one can imagine the English court saying that, well, just because a party happened to transact business in New York, we're not going to accept that's a submission, even though the New York court might do. But that's not this case. We have some specific contractual wording, and we submit that makes all the difference in this case. Now, if there had been any convincing argument given or advanced as to what that wording meant, which didn't lead to a submission, then
the transactional business doesn't mean that the New York courts will take jurisdiction. It simply gives them power, presumably, to take jurisdiction under the long-arm statute. It's not a compulsory jurisdiction. It's not something which is automatic, but simply because there is a transactional connection with New York, the court will take jurisdiction.
indeed. Indeed, my lord.
It's subject to form non-convenience.
Absolutely.
It's not subject to a CPR-type discretion, but it is subject to form non-convenience.
Indeed.
But there's a fundamental difference, isn't there, between the meaning of a contractual provision and its consequences. The meaning is a question of construction of the language. The parties may mean something without actually being aware or particularly welcoming the legal consequences that brings about, but that's tough.
Well, my lord, in this case, this particular wording, we say, is as good as the party sitting down and saying, we know that the New York courts exercise jurisdiction if business is transacted in the state. For the avoidance of any doubt, to avoid future disputes, we're putting some wording in, which we're both agreeing, which is going to satisfy that jurisdictional requirement, so there can be no argument about it, and thereby give the New York courts jurisdiction.
So they do it in a very obscure way.
Well, that's in a sense why we're here, because one has to give some wording, one has to give some meaning to that wording. And all that Lord Justice Potter was deciding was that there is an arguable basis which will require trial.
Well,
as whether or not there's that consequence.
trial on this point? I mean,
Well-
this is, we've got the material, it's uncontradicted, and it's reasonably specific.
Well, absolutely, my lord. But the question is that if there is no evidence before the court saying that wording, the deemed to be made in New York, has any other relevance, and therefore that's why we'd say that there is.
So, I mean, effectively, we could take the material and make up our minds. That's what it
Indeed,
means.
indeed.
Has he sufficiently spelt it out? I mean, where does the witness expressly spell out your point? He doesn't.
Well, in the passages which we've
Got
all
to
read
read them between
concerning
the lines.
transacting business, which is paragraph 24, which my Lord Sumption identified for us earlier. It's a transaction of business. Lord, a further point made by Mr.
I mean, he nowhere says, does he, that the first few words of clause 10 amounts to a transaction of business within the meaning of the...
Well, that may be going further than perhaps the expert should do. He's basically simply identifying there what the rule is, which is a transacting business. And then it's, again, for the court to decide whether or not that would be satisfied.
Your
No, but that
evidence
surely
is evidence.
can't be right. That must be, if he's giving expert evidence of what the foreign court would do, then surely he's got to grasp that nettle.
Well, that's the conclusion that Lord Justice Potter came to from that evidence, and we say that's a warranted conclusion, which is that he's explaining here why the New York court has jurisdiction, and he's setting out the rules.
Your evidence and your submissions in the American proceedings are absolutely clear, in fact. They make it clear that a contract being made in New York is one of the factors, maybe an important factor, in whether there's been a transaction of business in New York, and it goes no further than that.
Well, but with the proviso, Lord, which is this is not just a case where the contract has been made in New York, but going further than that, the parties have contractually agreed with one another that they're never going to deny that. And that can only have one consequence. And I'll be going over ground to say what the consequence is. But the parties are warranting to one another, we are going to agree henceforth that this contract was made in New York, whatever the facts may be, with only one consequence. A further point made by Mr. Driscoll is the fact that what has this got to do with bankruptcy claims, which are made by the trustee? That's his first point. But in a sense, that again is a matter of New York law. If the New York courts have jurisdiction, it's a matter for the organisation of business in New York, for the courts there to say which claims are in and which are out.
Well, it's probably a matter of construction of the submission agreement.
Indeed, but at the moment, the evidence before the court is, and we know this because of Judge Lifton's judgment and the case law referred to in the notice of motion, that the New York courts regard the making of a customer agreement with a deemed to be made in New York wording in it, plus the transacting business, is sufficient to give the New York court bankruptcy jurisdiction. No. So where we get to, my lord, ultimately, is that, it says where I began, which is the wording has to be given some effect, and there is only one essential argument to give wording that effect, and there is a principle, which was well known in English law, and I suspect it's a principle of US law as well, which is that you generally try and give every provision of a contract, particularly a commercial contract, some meaning. And on Mr. Driscoll's arguments, that's kind of surplusage, that wording, in a way, because it doesn't achieve anything.
Well, he says not. He says it may have taxation, regulatory or public law consequences.
Maybe, but again, where's the evidence of that? If that's the case, that may be a matter for, if the matter reaches a trial, and there is a convincing case put forward that the wording has some other meaning or effect in New York, no doubt the court in Gibraltar can adjudicate upon that.
But it does have a meaning. It means that the contract is deemed to have been made in New York. That's what it means and all it means. And the consequences of that and whether the parties like what they've done is a completely irrelevant matter.
Indeed. My Lord, I'm only responding to my Lord Newberger's point that Mr. Driscoll has put forward some other explanation of consequence. That may or may not be right, but there's no evidence of what the consequence is.
The AWB point.
Indeed. Yeah. But it's ultimately a matter for the organisation of business within New York and for the New York courts then to decide whether or not they have jurisdiction, if this court says that there is enough to confer jurisdiction on the New York courts.
But it becomes a circular argument. The clause means that the agreement is deemed to be executed in New York with all the consequences, if any, that carries.
Indeed. And then if the consequence is that, in fact...
The fact that you can't point to any other consequences doesn't mean you therefore give it, if your argument involves giving it an artificial meaning.
Well, in our submission, we're not giving it an artificial
meaning. No, I know not.
Yes.
But what I'm saying is if it is an artificial meaning, then it doesn't seem to me the fact that hasn't got any other meaning, hasn't in practice got any other effect, and you therefore give it an artificial meaning. I appreciate your point, is that it may appear to an English lawyer to be artificial, but it isn't to American law, and this has to be construed according to US law.
And giving effect to the bargain. So is there an indication of consent to the exercise?
Is the bargain, is what we've seen is that a whole range of transactional issues were relied on, presumably because they were felt to be relevant. If all you would have, the only connection with New York was that it was made there, or taken to be made there, is it not quite possible that would be an insufficient transactional link to justify the New York courts taking jurisdiction?
Well, in our submission, in and of itself, this is a matter that would need to be explored in evidence in due course. In and of itself, making a contract in New York and expressly agreed to be made in New York is a basis for the New York court exercising jurisdiction. One doesn't need the additional factors. And what's happened here, as lawyers often do, is that they put everything in, they throw the kitchen sink.
Do you mean that the New York court couldn't say in that situation there is no sufficient transactional link because the whole of everything else is European? It could, I mean, under foreign convenience.
Well, in other words, it is sufficient to get one's foot in the door to say that this contract was made in New York. The parties agreeing that.
It's a strong starting point,
Absolutely, absolutely.
but it's not the end of it.
Absolutely.
Do we have the CPLR 302A1?
I think we have it actually in.
You can get it on this.
I've certainly got my own copy of it printed out, and I think it
no,
was
no.
set out in the. As I can supply a copy. I've got my own copy here. I think was it not set out in the judgment of?
Only part of it. And only, I think, the first head.
I've got a copy here which I can have copied and then provide.
We can have it copied.
Indeed, I'll just. This was the long arm statute, my lord. That
302.
302. Yes, I've got a copy here.
Thank you very much.
My lord, the last part of my submission was going to be on in relation to the cases, and we've set out our answer to each of the cases, the older cases in our case.
Yes.
But one important point I would emphasise about those is, first of all, that in none of those cases is there the additional wording. They are simply cases, in large part, where there is a choice of law and no more, no additional wording. And it has never been our case that a choice of law clause on its own amounts to a submission to jurisdiction. And the second point I'd make, and this is quite an important point to bear in mind when going through those cases, is that...
Can I just
certainly.
say on that? Your evidence on choice of law is the same as your evidence on deemed to be made in New York. So why is it different?
Because we have, in this particular case, we've got the doing business, which goes over and above choice of law.
No, if I've understood the evidence correctly, and I have to go back to Mr. Zabalos, he relies equally, or in fact your submission to the your motion in support of the default judgment relies equally on made in New York and governed by New York law.
Well, on both of those factors, yes.
Yes.
That's
So,
right.
You now say you're not relying on governed by.
Just on.
What's the difference?
No. I think our submission is, my lord, we're not relying just on choice of law. So in those cases, the earlier cases, they're all cases where there's a choice of law and one can't jump from that to there being an agreement as to jurisdiction.
But if I've understood your evidence correctly, it's the same evidence on made in New York, which is that governed by New York law clause gives the New York court jurisdiction.
No, well, my lord, it's two parts. First of all, what's the law to be applied in construing the agreement? New York law. Then secondly, under New York law, does this wording have a specific result?
Yes.
That's essentially the case.
Yes, but there's no distinction drawn in your evidence between made in New York and governed by New York law.
Well, my lord, in Mr. Zabaya's
Is that right?
paragraph 24...
As I understand it, what Mr. Zambelos appears to be excluding the possibility that New York proper law is a ground for long-arm jurisdiction, because he seems to be comprehensively setting out three cases in which a non-domiciliary can have jurisdiction exercised over him.
And Lord, he's there setting out a basis for jurisdiction, not based upon New York law being the governing law of an agreement, but general New York law jurisdiction.
He is, as I understand it, these three cases are the only cases where New York courts exercise jurisdiction over a non-domiciliary, and they don't include proper law as an independent ground.
Indeed, my lord.
Right.
But paragraph 55 of your motion relies on both. And as does...
I'm just going back to... Sorry, my lord, is that page 133?
Yes. Yes.
Yes. So it's both deemed to be made in New York and subject to New York law. My Lord's quite right there. But in Mr. Zabias's evidence that we've just looked at, it's the point there made is not about New York law, but about the three
And
separate.
so does paragraph 20 of Mr. Zebayos's evidence.
Well, I think, isn't he referring there to, isn't 24 given as the reason for the statement in the first sentence of 20? I don't think he's suggesting, he's saying,
Well,
not by virtue of it being New York law, but because New York law refers one to the three factors in paragraph 24.
Indeed, my Lord.
Yes.
But I was
22 says by agreeing to a contract governed by New York law, that's a transaction of business in New York. In fact, he's actually, his whole emphasis is on governed by New York law, not on made in New York.
Well, there is also, my Lord, the paragraph 24, which is transacts business as well.
Yes, but that's the CPLR. But where he gets to, it looks at from 20 and 22 that the main factor that he's relying on transacting business within the state is the contract being governed by New York law.
Lord, it goes further than that. With paragraph 22, it is well settled under New York law that by agreeing to a contract governed by New York law involving the transaction of business in New York.
So it's the two factors.
Yes. Lord, I was on the fourth part of my submission, which was the cases. In our own written case at paragraph 19, page 0463, we've gone through each of the cases and explained why they don't help. And I've made one point, which is that unlike certain of those cases, this is not a case where there is just on its own a choice of law. But the second point I'd make, which is quite important to emphasise, which is many of these cases, and the Rubin case, in fact, is a prime example of that, are not cases about contractual agreement. They're really about cases where there has been some other conduct, such as, for example, being a partner in an overseas partnership, which are said by implication essentially to amount to a submission on the facts. But ours is not a submission on the facts case. It is a case which starts and ends as a matter of contractual construction. Lords, I've essentially been through my case now. Unless I can assist you any further, those are our submissions.
Anything? Thank you very much indeed. Mr. Azzopardi. Yes, but yes.
Lord, the only point Mr. Azzopardi reminds me I should have made is, and I'm sure the court's well aware of this, is the fact that this was a summary judgment application, where the further evidence of New York law as to what...
I understand that was a thread that ran through your argument, but you're quite right to emphasise it. Thank you. Thank you. We'll rise now briefly to consider where we've got to. We'll be back within 10 minutes, hopefully less. Thank you. Court will now be adjourned. Mr. Driscoll, is there anything you would like to say?
My Lord, only this perhaps. My experience before the Gibraltar Court of Appeal was that, as I've put it in the, and as we put it in the statement of case, that the one argument that I ran, it did not get a mention, and perhaps I can just remind you of that argument in case it becomes relevant. What Dice's fourth case requires is that there should be an agreement to submit to the jurisdiction of the foreign court in respect of the subject matter of the dispute. My submission is that one of the reasons why there was no agreement in this case, and this may not be my best point or my first point, but it's one of my points, is that the subject matter of the dispute was an avoidance claim brought by the trustee in bankruptcy in the exercise of his statutory powers.
This is the AWB one.
Yes. The customer agreement was an agreement between Mr. Madoff's company and my client. And as the law stands at the moment in this case, Professor Klee's evidence is that the trustee in bankruptcy succeeds to that contract and the contract has not come to an end or been avoided or anything of that kind, that if there is a trial, there may be issues that would have to be determined at trial. But whilst the trustee in bankruptcy succeeds to the position of Mr. Madoff's company, so far as the customer agreement is concerned, Mr. Madoff's company never had the right to seek to avoid the transfers to my client as preferential payments or fraudulent payments on the part of Mr. Madoff's company. This is a right which is only available to the trustee in bankruptcy. So if one is asking, is there an agreement to submit to the claim made by the trustee in bankruptcy in exercise of his statutory powers arising out of the customer agreement, our answer is it can't possibly be such an agreement, because at very best the agreement relates to disputes that arise under the contract.
Yes, I see.
That is a submission which I made below, and which I...
What is Mr. Saini's answer to that? He does address it somewhere.
I think, in fairness, if now you've raised the point, probably the fairer solution is to ask Mr. Saini what he says, but to bear in mind that you have the right to reply, because in a sense you're opening on a point that hasn't been covered. Is there anything more you want to say on that point at this stage? As I say, in fairness to you, it hasn't been dealt with by anybody. The right course is unless you want to say more about it, it's here, Mr. Saini.
No, I made the point.
Made the point.
It is in the statement of case.
It is in the document. Mr. Saini hasn't dealt with it. It's a separate point, one which, in fairness, whatever we decide on the argument so far.
Otherwise, apart from, again, one very small point,
Yes.
if I made submissions to your lordships, I'd only be repeating it.
Quite.
I believe the points that you put to Mr. Saini. Paragraph 53 was a paragraph. Paragraph 53 of the judgment
Yes.
was a paragraph that Mr. Saini relied on.
It was.
But when one... the key paragraphs in my submission are, in fact, paragraphs 51 and 52.
Right.
Although Mr. Saini relied upon paragraph 53.
Took us to 52 in part as well. Right?
Yes.
You say we should read...
Paragraph 53 of the judgment on page 29 does end, however, Ms. Fatima did not develop the argument, nor does it appear by way of expert evidence in Mr. Ceballos' witness statement. And the point was that the reliance on deemed to have been made in the state of New York.
Yep.
Like the Chief Justice, therefore, I limit my considerations to those passages. It is my submission that the trustee's case has shifted from time to time. Before the Court of Appeal in Gibraltar,
Well,
the thrust of it was indeed the words which begin Clause 10.
Yeah.
If your lordships look again at the statement of case, the emphasis appears to be not on the words that introduced Clause 10, deemed to have been made in New York, but indeed on the words which require rights and liabilities to be determined and the contract to be construed in accordance with the New York law. we've come back here today, and Mr. Saini now has reverted back to the case that they advanced in front of the Court of Appeal. I merely make that observation and say that it indicates in my submission that there is clearly here no agreement that would satisfy Dice's rule, and it's English law, and not an application of what's been described as the New York long-arm jurisdiction, which is relevant for present purposes.
So if those words deemed to be made in New York were sufficient to give the New York court potentially jurisdiction under the their long-arm provision, how would that be sufficient?
No, in my submission...
Why? Because there's no agreement.
George has been putting this to Mr. Saini. The effect of those words that agreement may be indeed one of the factors that would persuade the New York court to accept jurisdiction. But those words would not, when one is construing this this agreement with such admissible expert evidence of foreign law as one can use, those words would not be sufficient to amount, as a matter of English law, to an agreement to submit even a contractual dispute to the jurisdiction of the New York court. In this case, of course, it's the federal bankruptcy court.
Were the words referred to in the motion to the New York court? Is it or the claim? Yes, the motion. Tab 9. I'm just looking.
My recollection.
I don't think they are they?
Paragraph 55, my lord, page 1.
55.
Yes. We looked at that, yeah.
Yes. I see deemed to be made. Yes, there it is. It is there.
And subject to New York law.
Yes, and subject.
We
Yes.
looked at that.
So why isn't that sufficient, at any rate, for the purposes of the summary judgment proceedings?
Why is that not sufficient?
Yes, why is his argument not sufficiently put that?
Because, my lord, it's a simple question of reading the agreement and asking oneself whether or not, as a matter of English law, the parties in this agreement, customer agreement, have agreed to submit to the jurisdiction of the New York court. And the words are quite plain in my submission.
Under the long-arm statute, if I agree from London to provide you in New York with goods or services, and it's not made in New York and I don't go to New York, it's still, the New York court still has jurisdiction under 302A1. But that doesn't mean you say, I've agreed to submit to the jurisdiction.
No.
It's merely a consequence.
No.
The added factor here, says Mr. Saini, is that the clause, the words he relies on, have no point, except if they involve the submission.
Well, they have the point that they identify where the contract was made.
Right, I understand.
And there is English law, there's Emmanuel and Simons, which makes it clear that where the contract is made
Understand.
does not actually confer jurisdiction on the foreign court so far as an English court is concerned.
Yep. Thank you very much. Mr. Saini, Mr. Driscoll made 2 points, really. The second point was in reply to you. The first point is a new point. And
Bankruptcy point.
yes, and perhaps you haven't really had the opportunity to deal with that. I think you touched on it in terms of standing in the shoes, but it goes a bit further than that.
I'll restrict myself just to that. First of all, out of fairness to the Gibraltar Court of Appeal, the submission itself hadn't been forgotten by Lord Justice Potter, because if one goes to page, in the judgment, paragraph 43, page 24, Lord Justice Potter sets out Mr. Driscoll's submission there. If I may just take it up. It's, before this court, Mr. Driscoll has repeated submissions which he made below to the effect that for the purpose of Dicey's Rule 4, there was nothing in the customer agreement which amounts to an agreement to submit to the jurisdiction of the New York Bankruptcy Court, specifically that point, or the New York Court generally. And Mr. Driscoll has said again this morning that his submission is that, separately from everything else he says, where's the agreement to submit to the New York Bankruptcy Court's jurisdiction? And the answer to that is actually very straightforward, which is that if the customer agreement is subject to New York law, and there has been a submission to the jurisdiction of the New York courts, it's then a matter of New York law to determine whether not only simple contractual disputes are included, but also bankruptcy disputes. So the AWB case doesn't help here, because there Lord Justice Thomas was deciding, as a matter of English law, we have a firm distinction between contractual disputes and disputes that go to the Companies Court within an insolvency jurisdiction. That's as a matter of English law. As a matter of New York law, it's ultimately going to be a matter for trial. If Mr. Driscoll wants to say, OK, there is a New York jurisdiction here, but it stops at contractual disputes, how does it include bankruptcy disputes? Then he should put forward some evidence of that. And the way that Lord Justice Potter proceeded was that he dealt with the primary argument of Mr. Driscoll, which he rejected, which is that English law applies. And you will note that throughout the judgment of Lord Justice Potter, he's dealing with that argument, which is that English law applies in determining whether or not what's in Clause 10 should be construed as a jurisdiction agreement.
The trustees' actions were based on the long-arm statute, transactional basis of jurisdiction. That doesn't shed any light, does it, on the question whether he treated any contractual submission as extending by way of agreement beyond contractual disputes, which is always what a contractual submission would normally cover. It wouldn't normally cover non-contractual, or unless there was some tortious issue very closely connected, really the mirror image of a contractual issue.
My Lord, the answer is that there's evidence from Mr. Driscoll that the New York courts, when they have decided they have jurisdiction because of this wording, are limited to contractual disputes. It's a matter for the organisation of the courts in that state. So do the New York courts, when they see a contractual submission or doing business, say we are going to stop at just contractual disputes, or do they go further? Now, if Mr. Driscoll has put forward...
The transactional base is presumably, that's by itself independent of contracts. It looks at transactions. A contract may be one of the transactions, but it looks at transactions.
These are all indicia of presence in New York.
Yes.
Indeed.
So that, on that basis, the trustee came in and said, all right, my claim arises in the following factual circumstances, but we're construing the contract and asking whether it extended. Isn't that a matter of ordinary construction? Is there any principle which you rely on which gives the contract any wider scope than it would normally have if there is a contract?
It would be a question of New York law.
Well, I just develop that a bit further. If there was a simple question, does the clause apply to tortious claims for fraud or fraudulent misrepresentation? The starting point would be the wording of the clause. You wouldn't then go on to say, and that would be a matter of interpretation, and you could look at New York rules about interpretation. Are they wide? Are they narrow? But you wouldn't ask yourself, I think, about our law, our conflict clause rules, whether the New York courts would regard it as applying to fraudulent misrepresentation.
Well, Lord, one will take it in stage. In this particular clause, one would say, first of all, which is the law to be applied in construing the agreement? New York law.
Yes.
Okay. There appears to be a submission to the New York courts. Next stage. Third stage, does it include New York courts generally, or including bankruptcy court, or just New York courts dealing with, let's say, private law claims, contractual claims, or tortious claims? We said that at that third stage, it's a question of New York law. Now, if Mr. Driscoll had put forward evidence and said that, in fact, under New York law, this submission to jurisdiction evidence by that wording doesn't cover bankruptcy claims, then there'd be a debate about that.
Then that presupposes that your interpretation of the clause under New York law means that it's a submission to the jurisdiction of New York courts generally without limitation, subject to any limitation.
But it must be matters arising out of the contract, and there's no dispute here that the sums which are, if one goes back to the complaint, the sums which are the subject of the claim, the redemption, the $180 million, were taken out from Madoff's account shortly before the fraud was discovered, and those were sums paid under the customer agreement. So they're not unrelated. These are sums paid under the customer agreement, which were sent over to Mr. Madoff to be managed and then withdrawn. So there's certainly a connection with the customer agreement.
The dispute is about whether those sums were recoverable by virtue of an avoidance of the contract. and the avoidance of the contract is not a contractual issue, not an avoidance on insolvency grounds.
Well, the sums themselves are paid under the contract, and the question of whether or not the jurisdiction of the New York court, as a result of this clause, extends to bankruptcy claims is a matter of New York law.
Yes, but it's only, the claim is based on New York bankruptcy. I mean, the logic of your argument is that the liquidator ought to be, or the trustee ought to be arbitrating. Because, I mean, the arbitration clause couldn't be wider, could it?
Well, he could have, if a point had been taken in the New York courts that
But it wasn't
this should be,
taken,
it was
right.
never taken. They just decided to ignore the proceedings. They could well.
Yes, I mean, you would presumably vigorously argue in New York that a bankruptcy claim is completely different from a contractual claim that's caught by the arbitration clause.
Well, there is learning, which we haven't gone into, which is that arbitration clauses are sufficiently wide in New York that an arbitrator could, in principle, start adjudicating, and then there'll be a question as to whether or not the arbitrator should release the matter to the bankruptcy court. So the simple answer, as a matter of English law, would be that one arbitrator can't possibly be adjudicating upon statutory avoidance. But I'm informed we don't have the evidence of this, but it's not that straightforward in the US.
Well, where is the evidence to support the contention that if you're right on the arguments you were advancing before, nonetheless, in light of Mr. Driscoll's further argument, which you're now addressing, does Mr. Zabelos deal with that?
Well, Mr. Zabias is saying that the New York courts generally have jurisdiction concerning these transactions. He's not distinguishing between bankruptcy claims and, say, contractual claims.
But he's not dealing at all with bankruptcy.
No, because the point...
That's rational from his point of view, because he is pointing to the indicia in New York law of presence in New York.
Yeah.
And if you're present in New York, you may be subject to the jurisdiction of any number of courts for any number of purposes. Yeah. But that doesn't answer the question posed by Dicey Sub-Rule 4. Has there been a contractual submission to for the purpose of the question before the New York court?
And you say, in effect, that way of putting it means that the 2 points go together, effectively.
Indeed, and we know...
You're right on the one you were developing, and then your right is against Mr. Driscoll's, as it were, further argument.
Indeed.
Although it was always there. And if you're wrong on the one, then you're also wrong on the other.
Well, all I'm interested in is establishing that the judgment itself, which was an avoidance judgment, is one the subject of a submission by agreement. But going back to the question of evidence, one sees the complaint and the motion, I emphasise again, refers to specific decided case law in New York concerning this very customer agreement and establishing that a bankruptcy claim, that's a judgment of the US Bankruptcy Court, a bankruptcy claim lies as a result of, amongst other matters, this kind of wording agreed in a customer agreement.
That brings us back. Yeah, where do we find that?
That's
But that really brings us back to the
motion. I believe it's
Yep.
paragraph 55. That's
Page 133.
I believe that judgment may have been produced before the court below. It's not in the.
It's not in the bundle, no.
But I've got a copy of it here, because I just handed up. I'm not going to make any submissions on it, but it's something which is available on the web.
Yes.
If anyone wants it,
all of them are
I'll provide
available
this
on the web.
to my friend as well.
Okay.
And just where do you deal with this point in your...
Right at the end of our case, which is that it's paragraph 31.5.
Yes. Thank you very much.
And it was said by Mr. Driscoll that this omission vitiated the entire judgment. But the reason that it disappeared,
Yes.
effectively, is because Lord Justice Potter rejected the prior argument that English law applied rather than New York law. And essentially what the Court of Appeal was saying was once New York law applies, it's a matter for New York law to decide which claims it has jurisdiction over.
Yes, I see. Yes. Thank you. Very well. Anything else you want to add?
No, my Lord.
Thank you very much indeed. Mr. Driscoll. Anything you want to say in reply?
My Lords, I've got nothing to add, only to say that I haven't even read the judgment that's just been handed up to you before, but I'm not asking for any indulgence because I haven't read it. There it is. It's been put for your Lordships.
Thank you very much indeed. We're grateful to you for dealing with this matter expeditiously and clearly in oral argument, and we're also grateful to all those who were responsible for preparing the written cases. The board will take time to consider what advice humbly to tender to Her Majesty. Thank you very much.
Well, can I just raise one point, which is what should happen, and again, I'm concerned about not wasting the court's time, in the event that there is a settlement reached.
I think if you'd be good enough to tell us, we will decide then if you have submissions as to whether we should or shouldn't issue a judgment, then you're quite welcome to give them to us. Whether we decide to issue a judgment or not in the end is up to us.
What sometimes happens is if I know the court will go away and start drafting a judgment or judgments. If the court's not going to do that for a certain time, then it may put pressure on the parties to actually finalise things.
Well, I suppose I'm not saying we would do this, but one course for us to take would be to notify you that a judgment's ready if we don't hear from you before, and you can then make submissions about what we should do with it. In particular, whether we should...
before having seen it.
Yes, before seeing it. That would be one course we could take. I'm not saying we would necessarily take any steps in relation to it.
What I was going to suggest, unless the court has a burning desire to go away and start drafting immediately, is that if we could inform the court of progress, say, by Friday this week.
Well, I think that we are aware that the case may well settle and that a judgment may not be needed so far as the parties are concerned. The parties are welcome to contact us and tell us what's going on and make any submission they like. I can't assure you that whatever submission you make will be complied with, even if it's agreed, as you've discovered this morning. But subject to discussion, it might be that unusually we could let you know that a judgment was available before it was provided to you in draft. But I wouldn't want to commit us to any particular course.
So my concern was not necessarily that matter about the judgment being out there. It's just really a question of the court's time.
No,
the court's going to progress with
having chosen to listen to it,
yes.
We take the consequences. But we're aware that it may be that from the point of view of the parties, a judgment may be unnecessary. And therefore, it may be that if we were to decide not to issue a judgment, any work being done on the judgment in the next few days may be a waste of time. But that is a risk we can take, but it's kind of you to think of us. Thank you. But as I understand it, there's no other submission in that connection. So my idea of telling the parties that a draft judgment's available is not appropriate. We'll just make it available in the usual course or not, as the case may be. So we will take time, I suppose, to consider whether Her Majesty need be troubled with this. And if she is, we will take our time to consider what advice to tender to her. In the meantime, the parties are welcome to get in touch with us, preferably on a joint basis. And if not, for any reason, then with copies to the other side, obviously. But we're not expecting anything, but you're welcome to do so. And if there's a settlement, then yes, you ought to let us know as soon as it happens. Thank you very much indeed. Thank you for raising that, Mr. Saini. Court's now adjourned.